Dear students, welcome to all of you. Today we are going to discuss constitutional conventions. The learning objectives of this discussion will be to know about the meaning and definition of constitutional convention, the importance of constitutional conventions, sphere of constitutional conventions. As we all know that Constitution of India, being the dynamic document, has to keep pace with the changing socio-economic and the political conditions of the nation. It was drafted with this aim to suit the present times as well as the future needs. The life of nation is not static but dynamic, living and organic. Its social, economic and political conditions change from time to time, creating new problems and situations, thereby altering the complexion of older ones. No constitution is perfect as to provide for every contingency that may arise in future. It is therefore possible that a constitution drafted in one era and in a particular context may be found inadequate in the next era in another context. It thus becomes necessary to have some mechanism, some process by which the constitution may be adapted from time to time in accordance with the changing contemporary national needs. The modes of adapting the constitution from time to time to new circumstances may be either formal or informal. Informal methods include judicial interpretations and the conventions. The Constitution of India is a very comprehensive document, and many conventions in British Constitution are mandatory provisions of Constitution of India. Yet it has many grey areas that are filled by the conventions. Dear students, first of all, we should know as to what Constitutional Convention means. Constitutional Convention, also called as non-legal rules, are actually the norms which arise in the course of time as a result of practices followed over and over again. Such norms are known as customs or usages or practices or conventions of the Constitution. The Constitutional Convention is an informal and uncodified procedural agreement that is followed by the institution of the state. The Constitutional Conventions come into play when there is no given rule to cover the situations at hand. It is difficult to find out a precise definition of constitutional convention. However, few attempts in this regard have been made. Hood and Phillips, the great scholars, gave the following definition to constitutional conventions. They said, I quote, "Rules of political practices which are regarded as binding to those whom they apply and which are not laws as they are not enforced by the courts or by the Houses of the Parliament." Constitutional convention consists of various practices, customs, maxims and precepts of political ethics. Jennings has observed that regarding the constitutional conventions as, thus within the framework of law, there is room for the development of practices, rules which may be followed as consistently as the rules of law which determine the procedure which the men concerned with the government follow. According to Keaton, the conventions of the Constitution are the unwritten principles which, though they could never be enforced by the law in the courts, are nonetheless rules, since in fact the players of the constitutional game do observe them. There are certain characteristic features of the constitutional conventions, like conventions are the rules that define the non-legal rights, powers and obligations of the office holders in the three branches of the government or the relations between the government or the government organs. Conventions in most cases can be stated in general terms, their applicability in some circumstances being clear but in other circumstances uncertain and debatable. They are distinguishable from the rules of law, though they may be equally important or more important. They may modify the application or enforcement of rules of law. When we look at the structure of the central executive of India, it closely resembles to the British model, which functions on the basis of unwritten conventions. However, in India, some of these conventions have been reduced into writing in the Constitution. For example, provisions regarding the appointment, tenure and collective responsibility of the ministers. But some matters are left to the convention, as for example, concept of ministers' responsibility for the acts of his subordinates. Chief Justice Ahmadi in the case of S.P. Anand versus H.D. Devi Gowda observed that the conventions grow from the long-standing accepted practices or by agreement in areas where the law is silent, and as such a convention would not preach the law but will fill the gap. Constitutional Convention provides the flush which clothes the dry bones of the law. Now we will move to importance and the need for Constitutional Convention. It would be wrong to suppose that the Constitution, with all its prolixity, finally settles all the problems of the government. It leaves a lot of matters to be taken care of by ordinary legislation. It also provides scope, though not so much as in Britain, for the growth and development of conventions. Thus, the relationship between the President and the State Governor and his Council of Ministers, the concept of ministerial responsibility for the acts of his officials, the relationship between the Prime Minister and the Chief Minister in the state and his Council of Ministers, the appointment of State Governor, dissolution of Lok Sabha and the State Legislative Assembly by the President or the Governor respectively. These relations between the President and the Governor are some of the matters which are left to be evolved by conventions. Conventions play a more significant role in unwritten constitution than in a written constitution. Britain is one of the best examples wherein the convention can play a very important role and does play. The main purpose of the Constitutional Convention is to ensure that legal framework of the Constitution retains its flexibility to operate in tune with the prevailing constitutional values of the period. Although the conventions are not legally enforceable and the sanction behind them is moral and political, some conventions of the Constitution which set norms of behavior for those in power or which regulate the working of various parts of the Constitution and their relationship to one another may be as important, if not of greater significance, as the written word of the Constitution itself. This is particularly true of the role of conventions in a system of parliamentary democracy having a constitutional distribution of powers between two or more levels of the government. Now we will move towards the sphere of constitutional conventions and the judicial interpretations. Conventions operate in several ways. First, a convention may nullify a constitutional provision in practice without formally abolishing it. A well-known example of this is to be found in fact that in some countries the legal power of the head of the state to veto a bill passed by the legislature is never exercised by him on the advice of the ministry. 2. A convention may work by transferring powers granted to one authority in the constitution to another. That is what usually happens in a country with a parliamentary form of government where legal powers formally vested in the heads of the state are effectively exercised by the ministry. 3. A convention may affect a constitution by supplementing a provision therein. Conventions have made it possible for a monarchical constitution to work on the democratic lines. The prerogative power of British Crown to veto a bill passed by the House of Parliament has disappeared. In India, conventions operate in several areas, the most significant of which is the relationship between the executive and the legislature. Like the relationship between the President or the State Governor and his Council of Ministers, the concept of ministerial responsibility for the acts of his official, the relationship between the Prime Minister and the Chief Minister in a state and his Council of Ministers, the appointment of State Governors, dissolution of Lok Sabha or a State Legislative Assembly by the President or the Governor respectively, the relationship between the President and the Governor are some of the matters which are left to be evolved by the conventions. For instance, the President is empowered by the Constitution to appoint the Prime Minister, but the Constitution provides no guidance as to who should be appointed as the Prime Minister. Here, conventions regarding the appointment of Prime Minister plays an important role in guiding the President. Article 75, Clause 1 of the Indian Constitution gives the President the right to appoint the Prime Minister. In normal circumstances, it is the leader of majority party in the House of People, that's the Lok Sabha. But in circumstances where the Prime Minister dies in office or resigns, the President will have to exercise his personal judgment. Also, in circumstances when the party may have no recognized leader or either of the two parties may be able to form a government and command the support of the House of the People. In such circumstances, the President may choose for a person who could form a coalition with the help of two or more parties and command the support of Lok Sabha. It was such discretion that President Reddy exercised in 1979 after the fall of Janata Ministry in inviting Charan Singh to form the ministry and also in not inviting Jagjeevan Ram to do so after Charan Singh resigned and advised the dissolution of the House. Articles 74 and 75 of the Constitution of India, which deal with the composition and the status of Council of Ministers, are sketchy and very generally worded. The framers of Indian Constitution left these matters undefined so that these may be regulated by the practices and the conventions. The conventions operating in Britain are very relevant to India and can be adopted suitably to meet the conditions prevailing in India. Honorable Supreme Court has emphasized upon the importance of bridge conventions to interpret the constitutional provisions in India, as for instance, the decision of UN Rao versus Indira Gandhi. Supreme Court observed that we must interpret Article 73, Clause 3 according to its terms regardless of the convention that prevail in the United Kingdoms. If the words of an article are clear, notwithstanding any relevant convention, effect will no doubt be given to the words, but it must be remembered that we are interpreting a constitution and not an act of parliament. A constitution which establishes a parliamentary system of government with a cabinet. In trying to understand, one may well keep in mind the conventions prevalent at the time of constitution was framed. The Supreme Court emphasized that conventions operating in Britain governing the relationship between the Crown and the ministers are very pertinent to the Indian Constitution as well, and the formal provisions of Indian Constitution should be read in the light of those conventions. In Shamsher Singh versus State of Punjab, the court stated that it was not correct to say that the President is to be satisfied personally in exercising the executive powers. The President is only constitutional head or the formal head who exercises the powers and functions conferred on him by or under the Constitution on the aid and advice of Council of Ministers. Whenever the Constitution requires the satisfaction of the President for the exercise by him any of the powers or functions, it is not the personal satisfaction but in the constitutional sense the satisfaction of his Council of Ministers. The President's opinion or the President's satisfaction or decision is constitutionally secured when the ministers arrive at such opinion, satisfaction or the decision. The decision of any minister or officer or under the rules of business made under Article 77 Clause 3 is the decision of the President. The argument that an order could not be made by a minister without reference to the President is untenable. Describing the nature of the government, the court observed that it is a fundamental principle of English constitutional law that the ministers must accept responsibility for every executive act. In England, the sovereign never acts on his own responsibility. The power of the sovereign is conditioned by the practical rules that the Crown must find advisers to bear responsibility for his actions. Those advisers must have the confidence of House of Commons. This rule of English constitutional law is incorporated in our Constitution. The Indian Constitution envisaged a parliamentary and responsible form of government at the centre and in the states, and not a presidential form of government. The court then said that whatever the functions vested in the President, Governor, whether executive, legislative or quasi-judicial, in nature and whether vested by the Constitution or by the statute, may be discharged according to the rules of business, unless the contrary is clearly provided for by such constitutional or statutory provisions. The court stated, the President as well as the Governor is the constitutional or the formal head. The President as well as the Governor exercise his powers as well as the functions conferred on him by or under Constitution on the aid and advice of Council of Ministers, save in the spheres where the Governor is required or under the Constitution to exercise his functions in his discretion. Whenever the Constitution requires the satisfaction of the President or any exercise of the President or the Governor of any of the functions or powers, the satisfaction required is not that of the personal satisfaction but the satisfaction of the Cabinet. That means the satisfaction of the Council of Ministers on whose aid and advice the President or the Governor generally exercise all his powers and functions. The decision of the Ministers or the officer under the rules of business made under any of these two articles, that is 77 class 3 and 166 class 3, are the decisions of the President or the Governor respectively. These articles did not provide for any delegation. Therefore, the decisions of ministers or the officers under the rules of business is the decision of the President or the Governor. In Constitution of India, there is a good scope for the growth of constitutional conventions, like the position of the President vis-a-vis the Council of Ministers, the Cabinet, a minister's responsibility for the subordinates' action, summoning, prorogation and dissolution of Lok Sabha and the State Legislative Assembly, assent of the President or the Governor to the money bills passed by the Parliament or the State Legislative Assembly respectively, acceptance of the Finance Commission recommendations by the central government. The National Developmental Council is another constitutional body, the powers and the functions of which are regulated not by the law but by the convention. Honorable Supreme Court of India has maintained and denied the existence of any distinction between constitutional law and an established constitutional convention. In the case of SC Advocates on Record Association versus Union of India, Justice Kuldeep Singh observed that we are of the opinion that there is no distinction between the constitutional law and the established constitutional conventions. Both are binding in the field of their operation. Once it is established to the satisfaction of the court that a particular convention exists and is operating, then the convention becomes a part of the constitutional law of the land and can be enforced in the like manner. In order to conclude, thus we can say that the constitutional conventions play a very significant role in the preservance of legal structures of the government. The main function of the convention is to guide the use of constitutional discretion. Certain important questions pertaining to particular situations to which the Constitution provides no answer, it is here where the convention play their part as a catalyst. Some conventions are well established and may be relied upon absolutely, while some are vague and may lead to manipulation for political purpose. For example, appointment of Prime Minister is to be done by the President, and the prevailing convention is that the person enjoying the support of absolute majority of the House concerned is appointed to the respective office. It has also come to limelight that the main purpose of the Constitutional Convention is to ensure that the legal framework of the Constitution retains its flexibility to operate in tune with the prevailing constitutional values of the period. It helps the Constitution to adapt as per the needs and desires of changing times. As the founders of the Constitution couldn't have foreseen and safeguarded the Constitution from future loopholes and hence left certain matters to be governed by the conventions, as they are important, if not of greater significance, as the written word of the Constitution itself. It has been rightly said that the Constitutional Convention provides the flesh which clothes the dry bones of the law. Hope that you might have understood and enjoyed the lecture. That's all. Thank you.